What is the writ petition number?
WP number 305 of 2021.
They are technical because they just file in the principal bench. In contempt application, this order be that contempt application.
Contempt and recalling application both are hard, my lord.
CPRC 5 2021. WPCRC 5 2021.
So I am not the order which I dictated yesterday while going to sign. My officer found that this is that the writ petition has already been disposed of. Now what he is submitting in a connected contempt proceeding, though there was an application for recalling of this order.
Recalling application
Filed by this one number 3.
But the recalling application is not also on record.
recalling of the can number.
Order reflects, but the order is not also on record. Let it go out of list.
Well, a recalling application was filed on behalf of the district primary school council.
No, understood, but this is not in the record. Neither is the recalling order. And it was what he is submitting, Mr. Kundu is submitting, this was filed in the principal bench. File is lying in the principal bench. The order, recalling the order, dismissing the writ petition or the disposing the writ petition is also lying in the contempt file.
Contempt, yes.
But this is not available.
As your lordship, we shall arrange for. We shall arrange for getting them at a sent to your lordship's court.
Yes, I don't know all the. Acha. It appears from the record that
the last draft item recalling application is right.
the hearing of the petition was adjourned yesterday. But on scrutiny of record, it is found that the matter has already been disposed of by the order dated September 23, 2021. Mr. To clarify the position, Nakilam, the matter was. To clarify the position, it has brought to the list today again under the heading to be mentioned. Mr. Pundu, learned advocate for the petitioner, submits that the order dated September 23, 2021 was recalled on an application filed by the
Respondent number 3 and 4.
Respondent number 3 and 4.
Primary court.
Stop. But the said order, stop now, but the said order is not on record. Mr. Pundu, stop there, further submits that the order restoring the writ petition in its original number and file is lying with the record of the contempt proceeding or with the connected contempt proceeding in the and the file is in the principal bench. Be that as it may, let the matter go out of list for the time being, with liberty to mention. Stop.
But kindly the direction was given to.
I don't know where the file
Yes,
is.
but-
You make appropriate prayer, take steps through the registry, it will be done. Write a letter. You know, it already is. No. Personal appearance.
My lord, this matter pertain to child custody.
I understand, but where is Mr. Chakraborty? Hey, okay. Unmute yourself, Mr. Chakraborty. বড় করুন ওকে।
My lord, I apologize, my lord. My lord,
Yes.
I am for the opposite party number 2. My opposite party, my lord, I have taken instructions from my client. My lord, if your lordship, my lord, my client, my lord, if your lordship kindly records my this submission, that for the last 4.5 years, the petitioner did not allow my client to visit her child even for once. My lord, my client is a patient of diabetes, has to take 3 shots of insulin per day. My lord, after only I instituted a suit for restitution of conjugal rights, she filed a complaint case under section 498A. My lord, while dealing with my application under section 438, this honorable court was pleased to take into account that fact and send the matter to mediation. She did not turn up in mediation. Now, my lord, here, when I filed this custody application, she when my child was of the age of 7 years, she snatched my child from my custody, took her from Thakurpukur to Dinhata, and then while filing an application for adjournment before this court, my lord, she stated that since the child has exam, the child cannot be brought before this court. My lord, regularly my wife contacts me. I am sending her when she is asking for guitar. I am sending her the guitar. A gold chain, I am sending her the gold chain. But my lord, for the last 4.5 years, I am deprived of any single glance of my child.
Sir, this is not done. One thing, suit is for restitution of conjugal right. Now, if you do not want to restitute, go back to your husband. It is better not to accelerate or enhance the tension between the parties. So you know what is the way it should go. Either go back or you decide the permanent solution, because this fight has an impact on the child. This
I
is
bow
one
down to
thing.
your lordship.
Second, whatever may be the situation, his custody petition come over here, no doubt about it. But he has a right to see his child. Why you are objecting the visitation?
I am not objecting. We never asked for visitation of the child.
Let us now he is showing his interest, and ask your client to give him a visitation right. Matter will come and take another instruction, what she actually driving at, what she is wanting. If she wants to go back, go back. If she does not want to go back, let it be ended in a peaceful manner.
Yes, my lord, I agree with this proposition. But first of all, if the visitation right or all these things is to be allowed, then it should be in a proper jurisdiction. My client is not in a position to go to Calcutta.
No, certainly not. Certainly not. Where the child, father will come, father will see, there shall be a place where not the court, prima facie, not the court, either of your chamber or wherever, the father will visit the child on a scheduled date, maybe twice in a month. But above all, take instruction from your client, whether she is agreeable to go back. If she does not, what she is wanting. Dog in the manger policy will not yield anything because the rushing to the court, fighting, ultimate effect is on the child.
Yes, my lord, we absolutely agree with this. But to do all these things, Dinhata is the proper place.
No, this matter will brought back. A court of world must see the paramount. You know the
Yes,
paramount
yes.
interest.
Consideration is the welfare of the minor.
Welfare of the minor. Now, for the welfare of the minor, this peacefully and a joint custody visitation, the way they work out.
Yes, I will convey the.
It is rest assured the matter will come in the Jalpaiguri.
Dinhata, my lord, additional district
judge is there.
Additional district judge is there.
Very well. Under the Jalpaiguri district judge.
No.
Under
Kojbihar.
Very well. That will go to the Dinahata. You take it. Then
I will convey this as well as my feelings to
please
settle the matter.
Yes. I don't have much time. And this, please convey it to your client and get the appropriate instruction by tomorrow. That whether then this term I will record, and this time near the Kojbihar Mediation Center, parties will appear before that. After transfer of the record of this case, district judge will take initiative. But I want to understand whether your client is at all agreeable or not. Come
Yes,
tomorrow?
yes, Mia.
Tomorrow 10:30.
Mike, I'm grateful to your lordships.
If necessary, ask her to be present tomorrow so that you can, because one proposal will come from here, you have to get an instant reaction of that.
From the yes,
mother
I will ask her, but the exam is going on. The problem is this.
of the child.
Exam of the child is going on.
Anyone responsible person of the family?
No.
No one. Yeah.
It's
Very well. You try to take this regarding
Instruction, at
the
least instruction.
place of visitation. Now, if it is in your chamber, your chamber
Is at Jalpaiguri, it is not possible.
Possible.
It will be at Dinhata.
Dinhata, because I do not want that mediation center or court premises, not a very congenial place for the child. Find out any place where you can suggest that where the husband can, or rather father can meet the child. And of course, in the mediation will be the ultimate final solution. Get her mind what she is now wanting.
Another thing is the child has attained the age of understanding. Whether she wants to.
No, sir, another thing, the child is in your custody. Therefore,
Yes.
7-8 years child may have some initial
prejudice
repulsion
against-
towards
Yes,
father
yes,
not seen. It is the duty of the mother to make her understand
But
that
it will-
father is necessary as I am.
It will take time.
It
Because
is
the
take-
relationship
let the ice break at least. But your contribution of your client in breaking the ice is necessary. If she is not rather helping the child to understand that this is your father, whatever between us, but you please make access, because ultimately she requires the father either for
Yes.
financial assistance at least.
That's right. A
Please make her-
125 petition is filed and huge amount is pending.
That he has to pay. There is no doubt. That he has to pay.
And warrant and ER was also issued against
No,
her.
that you just calculate the maintenance amount and
Now we
everything.
filed execution petition, so per my instruction.
No, you just come with the due amount, everything you will come out. The whole object to settle it forever, sharing custody means sharing visitation right, if they want to.
But
And if
at
they
this at this stage, without taking some time, the mother, possibly it would not be possible for her to instantly say,
No,
yes,
you
I will.
just take the initial
Yes,
mind,
yes.
not responding to restitution of conjugal rights. That means she is not willing to go back. At least prima facie it is.
Possibly, so far I have heard, not positively, it is her instruction that the husband filed a divorce suit,
Restitution of conjugal right,
restitution of conjugal rights.
not the divorce suit. That is the one. Please take instruction.
Yes, let it be sent to Dinata, and
It will go, but before that, an attempt should be made. You know, this is situation. Leaving the parties in tension will take us nowhere.
ultimately it will.
It takes
inflict
us
upon them.
nowhere.
Yes.
Yes.
No, this matter. This is a matter pertaining to the core staff of Darjeeling Polytechnic, my lord.
Well,
And on
please
the last
ask,
day,
my
my
lord,
My
and
lord,
ask
I
for the
directed the principal to appear before.
personal appearance of the
As
principal.
served,
He
my
is
lord.
the principal.
Why the service book has not been sent? Who is representing him?
Well, he.
What is the difficulty? If the service book of this,
Actually, sir, I have been given the task that has been put to me yesterday only. Regarding this matter, I am not doing anything about it.
you have taken charge
Task was
yesterday.
only Yesterday.
Please, sir, stand properly before a court of law. So, can I take that you will do it within a certain time?
Yeah, of course, I'll be requiring.
Because only you are to send the service book, I suppose.
Send the service book to the DI and they will. District inspector. Oh, this is the group D stuff, no?
No, this doesn't fall under the.
No, this doesn't come under the DI. I mean, it was a teacher. Cook. He's a helper, I think. He's a helper.
So you forward the service book to the
Service.
concerned authority.
Concerned
My concern authority is my directorate.
Directorate of Technical Education. Technical Education.
Within which time you can send that?
I can't give the exact time, but I can do it as soon as possible.
You have to give some.
I'll talk with them and whatever they say, I'll be sending it to them. No.
My lord, kindly fix a time.
No, of course, I want
By another one.
But kindly grant 4 weeks.
sending service book 4 weeks.
Well,
It is too. Service book is lying in the custody of
service
the
book-
head.
It has to be properly prepared and then sent.
Oh, it's not been updated.
No.
Mr. Varnari.
As your lordship pleases, my lord has heard this matter at length, my lord. Let it be parted
So,
and.
I mean,
my lord fix
I
it.
presume that within 4 weeks, you will be sending the service book to
4
this.
weeks.
To my.
And on
Yes.
the directorate, the respondent,
Number 2, 3, respondent number 3, my lord, Director of Technical.
acha, আসুন. In compliance with the direction passed by the court on December 8, 2023, Mr. Such and such, the principal of Darjeeling Polytechnic is personally present before this court. Such personally dispensed with. Stop. Mr. Rahman, he is represented by Mr. Mr. Rahman,
No. Government.
Mr. Rahman, London Street Advocate. Mr. Rahman, on instruction.
Government political.
Submits that the service book of the petitioner will be sent to the Director of Technical Education,
Director of Technical Education.
Government of West Bengal, respondent number 3 hearing within 4 weeks from date. Complete service book, complete service book. Updated service book. You are required to update the service.
Yes,
book.
ma'am.
The respondent. Para. the respondent on receipt of the said service book shall take immediate steps to disburse the benefit in terms of notification bearing number such and such dated
Page 12, page 12, my lord.
এখানে উল্লেখ লেখা আছে to the petition. Stop. The petition is disposed of with the above terms, WP number without any orders.
But one indulgement, kindly add one line that the petitioner will cooperate with the principal in updation of the service. And his cooperation is required.
বুঝুগুলোকে পড়ুন আমার বলে দিচ্ছি তার আবার কার
He is a serving staff. He is not retired.
আলো হবে পরে আলো। It is needless to mention that the petitioner is obliged to cooperate with the respondent number 5, no? He is
Respondent number 5.
respondent number 5 in updating his said service.
Grateful, grateful.
I'm deeply obliged.
Next one.
When a personal
My lord,
offense may be discussed.
similar matter, my lord, but in this case, my lord, the petitioner has retired in 2022. Also as mentioned in the last order.
Here he is the cook, I think. He is cook, nothing. The next petition. Cleaner. Cleaner.
Now, in this case also service.
My lord, here the difference is that initially he was the helper in the earlier rate petition. This is the cleaner. Group is not.
No, group, he is
He is not, he has superannuated.
Achha. But here the problem is service book or other thing?
Service book is the problem. He has to send the service book.
Service book only.
My lord, giving effect to this geo, my lord, that is
Okay.
also
Yeah,
What the purpose of the service
because
book is
Mr.
required.
Shah on the last occasion submitted because of the failure of the polytechnic to take appropriate
that was
steps.
his submission, my lord.
Yes,
but
what are
this-
the appropriate steps he is required to take so that the petitioner get the benefit of the
Because my lord, this geo also mentions a pension scheme, my lord.
literal benefits? Is he?
Literal.
Retired benefits.
Oh, he has not received the.
Nothing, my lord.
This is because of the non-application of the service.
What are the documents they are supposed to send? Pension papers has not been sent.
Pension papers need to be sent to the directorate.
Oh. So he has now the new incumbent. He does not know what is the
Yes.
position of the pension papers.
He will inquire within the time period. My lord, kindly grants the same 4 weeks. within
Achha,
the
look.
period.
The petitioner is a retired core staff in the boys hostel of Darjeeling Polytechnic at Karshiang. Stop. On superannuation, he has retired from his said service on October 31, 2022. Personal appearance dispensed with যেটা আগে ছিল in terms of the order date similar এটা তো personal আছে ঠিক আছে retired from his service on such and such date. So the petitioner is complaining delay in disbursement of his retirement benefits. Stop. Mr. Shahan Ahmed, AGP, on the last occasion submitted that due to the failure of the Polytechnic Authority, Darjeeling Polytechnic Authority to send the relevant pension papers to the directorate, the retirement benefits of the petitioner could not be disbursed as yet. Cannot be disbursed as yet. Stop. Mr. Shah, your appearance I can record here.
Not in this matter also, I'm appearing.
Huh?
I'm appearing for it.
You are alone appearing.
No, I'm with Mr. Sandeep Sarkar.
Okay. Mr. Rahman, Planted State Advocate, appears on behalf of the open respondent number. He's also
He's 5, respondent number 5.
is personal appearance into respondent 5 appears on behalf of the respondent number 5 also, and submits that within 4 weeks from date, relevant pension papers would be sent to the actor director যেটা বললাম, to the
Respondent number 3, my lord.
To the Director of Technical Education, Government of West Bengal, the respondent number 3, hearing. Stop. And, subject to the petitioner extending cooperation
Lordship.
in completing the pension papers. Stop para. The respondent number 5 is directed to take necessary steps. Stop. The respondent number 3, immediate on receipt of the pension papers, complete pension papers shall take steps for disbursement of the retirement benefit of the petitioner in accordance with law. Disposed of.
Grateful.
I'm grateful.
Grateful.
My lord, this is identical as item number 3.
I'm for the state,
Only
my lord.
difference is, my lord,
Led by
he's a
Mr.
cook,
Hirok
my lord.
Verma.
He's a cook. He's also core staff, my lord.
Course stop.
And he's serving as a cook.
You superintendent.
No, he has not superannuity.
No, my lord, he's serving.
This is এটা যেটা বললাম না, item number 3.
3, my lord.
Item number 3. No, 3 টার মতো এটা exact 3 এর মতো. Service book will be sent. Mr. Bormon, you are appearing in this matter. ওই Mr. Bormon. রহমানের জায়গা Mr. Bormon. ঠিক আছে? কোনো কনফিউশন নেই?
I'm grateful.
Item number 6, I'm for the petitioner. Served upon the Planted Advocate as well as the opposite party. I am seeking transfer of the matrimonial suit filed by the husband seeking resolution of marriage, my lord, under the Muslim law. Petitioner before lordship is the wife, my lord, and paragraph 12 to 17 are the ground.
So you are Jalpaiguri.
Yes,
He is in Kuchbihar.
Kujbihar Dinata.
Jalpaiguri to Kuchbihar distance.
My lord, it's about 142 kilometers, my lord. Dinata.
Where have you stated?
My lord, paragraph 13.
Paragraph
13.
Any other ground?
My lord, other there is no one to be at the in the house because they are totally dependent of. She is totally dependent on the relatives because she has lost her father in the year 2000 last year, my lord. So she is totally her family is totally dependent upon the relatives, my lord, and there is no one to accompany her.
Any other proceeding pending?
No, my lord, she has not initiated any proceeding.
Where is the plaint of this suit?
My lord, at page 11, my lord.
I mean, how this has been classified as mad food before the civil judge junior division?
Court is also proceeding with the same.
How this has been classified as mad suit? This is under District Judge Coach Bihar.
No, junior division. civil judge.
No, under the judgeship of
Yes,
district
under
judge
judgeship
বসে
of-
আর কাগজ দিন তো। না, sorry, আপনি না। একদম শেষে ধরুন, এই দার্জিলিং পুটিয়া ফাইলটা কোথায় আছে? বুঝতে পেরেছেন কোনটা? Stop. The husband has filed a suit classified as matrimonial suit number 18 of 2023 in the court of Learned Civil Judge Junior Division, Dinhata District, Coach Bihar. The petitioner is praying withdrawal of the said suit from the said court and transfer of it to which court you want it transfer?
Since it was before the civil judge junior division, I prayed for transfer with civil judge junior division at Jalpaiguri.
Very difficult to say that section 24 is withdrawal from a suit and for transfer of another court
Yes.
having jurisdiction.
Matlab,
If
carry
I-
directly then transfer it to the district judge, Jalpaiguri.
Why should I?
Because district judge will be able
No,
to.
certainly not. Mr. Pal, there is no avenue after this Tin Talaq gone. There is no avenue for them to get any divorce. Very difficult situation.
Let it be as prayed for. Matlab.
As you are paying
Yes,
Union Division fee. To the Court of Learned Civil Judge Junior Division
At Jalpaiguri.
and Jalpaiguri. In fact, section 24 does not apply here. Because you must have a competent court where the suit can be transferred. There is no competent court. Actually, you are praying a non-maintainable suit should go to another court. In a strict sense, section 24 has no manner of application. But the court cannot transfer it to a court having no jurisdiction. Oh, but
Court আছে। Stop. Any court. But there is two courts, Matlab.
Junior division in Jalpaiguri, we have
Two
two
junior
courts.
divisions.
Yes, two junior divisions. Which one? That would be.
let me, I am sending it to district judge will
Yes,
decide.
slot.
This court, although has a strong doubt about the maintainability of the suit and about the jurisdiction of the Learned Civil Judge Junior Division to entertain the such suit. But considering the fact that there is every likelihood of the petitioner likelihood of suffering an ex parte decree by the petitioner, this court is entertaining these application under application for transfer. Stop. All right. The petitioner is praying the transfer, withdrawal of the suit, said suit from the court where it is now pending and to the court and to the Court of Learned Civil Judge Junior Division Jalpaiguri on the grounds that she being a resident of Dinhata, Jalpaiguri, it would be difficult for her to travel to Dinhata district Jalpaiguri to contest the said suit as she has no one to accompany her to travel to Dinhata, which is almost 142 kilometers away from 142 kilometers away from her residence
142.
at Jalpaiguri. The financial crunch is another ground for another ground to seek such transfer. The petitioner is able to make out. Now, petitioner has made out justifiable grounds for allowing her prayer. As such, but therefore, the matrimonial suit, the records of the matrimonial suit number 18 of 2023 is withdrawn from the records of the Learned Civil Judge Junior Division Dinhata and is transferred to the Court of Learned District Judge Jalpaiguri, who, on receipt of the said record, shall send it to any of the courts of Learned Civil Judge Junior Division under his judgeship for trial and disposal. Stop. The department is directed to communicate this order to the Court of Learned Civil Judge Junior Division Dinhata District Coach Bihar and also to the Court of Learned District Judge at Jalpaiguri immediately. Disposed of. Grateful.
My lord, I am appearing in item number 7, my lord.
Lordship, praying
May I
for not
audible?
today, praying for not today, some technical glitch, the learned council Nilami Srinivas is not connected. Lordship,
Are you?
I am from respondent.
My lord, my lord, on the last occasion, my lord, I am for appellant. On the last occasion,
Appellant?
my lord was asked. I am for petitioner. I am for petitioner. On the last occasion, the regarding certified copy, my lord was asked for the certified copy of the DRT code. I have obtained the same just yesterday evening. I received the same, and kindly allow me an opportunity so that I can submit those documents by your supplementary affidavit.
Very well.
The
And he is
certified
also
copy is with
time.
me.
Very well. He is also seeking time. Mr. Bonik, Learned Counsel for the petitioner, appears virtually and prays time to the supplementary affidavit. Prays extension of time to file the supplementary affidavit as directed by the order dated December 8, 2023.
Right.
Stop. You are appearing for?
Respondent. Respondent.
In CO opposite party.
Opposite parties.
Number?
One or Bikasha.
Acha. Only sole opposite party. And
Sole opposite. There is only.
And accommodation is also prayed for on behalf of the opposite party. And then the prayers. Prayers are allowed. Matter it listen before the next category.
Grateful, my lord. Grateful.
Grateful.
Item number 8 kindly fixed on day after tomorrow.
Sorry.
Lordship, Learned Counsel advocate on record due to illness he did not come to today.
This is that matter, my lord. Lordship had asked for personal appearance of the petitioner, father, and the son.
Dismiss.
Lordship, kindly.
Where is the father? You're a bad son.
Lordship, one day accommodation, Lordship. Tomorrow, Lordship.
10,000 each man, father and mother.
10,000 each.
Per month.
Yes.
Father and mother.
Yes.
I'm just cancelling your deed of gift.
Lordship, one day accommodation. Lordship.
It should not be each, it should be 10,000. Only to the father, because only the father.
You
Yes,
see, Mr. Rahman,
yes, madam.
practically this was a consent order.
Yes. It's reflected from the order.
It's a consent order.
Yes.
Look here, if you do not appear tomorrow, I will ask the IC of this police station to throw you out of the property. Tell your client, he has consented. He consented before the magistrate. This is the SGO court, no?
Yes, madam.
Lordship.
Executive magistrate, and then you have challenged it. He has got the account number.
Yes.
Deposit the money by today. Tomorrow it is a very fateful day for him. Ask your client, come with the deposit of the money. Because he invited that the account should be disclosed so that he can deposit the money.
Lordship.
I will cancel the deed. I know how to throw you out of the property.
Lordship.
Without deposit money, if you come tomorrow. এটা কালকে 10:30 দেবেন তো 10:30 tomorrow. এই এটা এই ওই ফাইলটা থাকবে ভান্ডারির ফাইলটা থাকবে
apportionment of
Then
compensation
you are
between lesser
taking
and
to the
lessee.
merit of the arbitral award. That is a subject matter of challenge under section 34.
But what is the
The-
reasoning? When my judgment in the Prasad was considered, then why not 75% was awarded? It was one second,
34.
let me submit. In Indra Prasad, it was clarified that 75% of the land value will go to the tea garden.
Understood, but whether
but-
it is covering 34-4 situation or not, I am not on that your challenge to 34. Now, if you go, I think in arbitration act,
Look,
the relevant portion of this judgment,
Yes.
Yeah.
is there anything that has been covered by?
The first page of this judgment is cover everything of it. I relied on same judgment before the trial was proceeded.
There is no reasoning of 40%. What is the reason of giving 40% of enhancement to 40%?
Being agreed of that, we have also filed the same arbitral award challenge before London District Judge in 34-1.6.
which you have, which may receive 8 to 39, para 39.
37 দেখো না, 37
Open disorder. Go to it.
Yes, Mr. Ghosh, how you can overcome this judgment?
Millard, if Millard takes the judgment, Millard has meticulously gone through it, I know. Para 37. So a distinction has to be understood between the finding and the results. Now a finding is there. Millard kindly turns over to page 77. The first head of the calculation, 40% of the total valuation of 3.08 acres of land in claimant's share. That is one head of the total amount that has been calculated. So a finding with regard to how much valuation of land should be awarded to the claimant is there. We say that the reasonings in support of that is inadequate. Because prior to reaching to this finding, the judgments which were shown by us, the particularly Indra Prasad and Amar Granites, those were not considered. Why this case is distinguishable from those, why the percentage should vary from 75%, it should come down to 40%, that has neither been dealt with nor has been addressed by the learned arbitrator.
So your main grievance is that you have cited two judgments.
Yes.
Those who have not been
Absolutely.
properly dealt with.
Yes. Now, Millard, in addition to this, Millard, I will just quote Dyna Technologies also. Dyna Technology, Millard would kindly bear in mind, this is a 3-judge judgment, whereas IP Services is division bench. Millard takes para 36. Para 35. Para 35. This is also in context of 34 in general and 34(4) also has been dealt with.
Paragraph 35.
35. When we consider the requirement of a reasoned order, three characteristics of a reasoned order can be fathomed. They are proper, intelligible, and adequate. I say, my lord, this finding of 40% is unintelligible. Why the judge has arrived at 40%, there is no reasoning. It could have been 60%, it could have been 100%, but no reasoning has been given therein.
It requires hearing. This is saying.
Some copy upon the lordship. They have.
It has been served. My affidavit of service shows served. I can hand over another set, no difficulty, here and now.
But unfortunately, I will not be able to hear it. But this is a
Milord, kindly, Milord, here's and Milord, less down the law.
time constraint. Time constraint. This is really a very interesting point. you have
Interesting
there.
point, Milord,
Very
kindly less down the law.
very interesting point. Server a copy. Server a copy. It
Milord,
should have
kindly
come on the first day.
Milord,
It should come
tomorrow. Kindly.
tomorrow. Mr. Ghosh,
Milord,
I will try, but
2
server
PM,
a
2
copy.
PM tomorrow, Milord, here's it for 15-20 minutes.
15-20 minutes matter is not this. You are rightly pointed out that judgment has been considered in
Yes,
this.
yes. That judgment has been considered, and what another judgment, Kinnori Mollik, has been considered. But Kinnori Mollik is essentially on the point that without having preferred and specific application under 34(4), no remanding back. So Kinnori Mollik is not of much help here. We are on the reasoning and the finding and the correlation.
Inadequacy of the reasoning
Yes.
to a finding is a ground under 34.
Ground under 34(4). So I showed three things:
Mr. Singh, get yourself prepared.
improper, intelligible, and adequate. These are the three expressions which means which have separate connotations. I am on intelligible,
Or inadequacy.
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 If it is unintelligible, definitely it leads to inadequacy.
Mr. Rama,
Definitely.
I will try to.
Please,
myself.
Milord,
I
kindly
will try to get.
Yes.
It's a very interesting point you
Milord
have
has
developed.
gone into it. Milord has considered the judgments. Milord can carry the files to Calcutta and pronounce the judgment there. No difficulty. We will wait.
Friday, lordship.
Friday. Let it be tomorrow.
Friday, 10:30, lordship. First matter.
Friday.
Tomorrow.
Are you sure that I will be sitting Friday?
Tomorrow.
This is whole difficulty of these 10 days, you know. So taking up the point of laws, this is real difficult. This is now this new act is taking a shape.
Yes.
So whatever you will do, it has got an impact on not on national, beyond national.
Yes, yes, definitely.
So one must be cautious enough to deal with it. 34(4) is as if it cannot be used as if whenever the party will ask and it will be remanded.
My submission would be that 34(4) is primarily discretionary. It's a discretionary power given to the.
Yes, yes, definitely. There is no dispute with that.
But whether the trial judge has exercised his
That is-
arbitrarily
yes,
or
that is
not,
what
that
is
has
to
to
be
be looked
found. Yes.
into.
Yes.
That is what is to be.
Yes.
In this case, this is a fit case for remand to make the judge understand
What 34(4)
what 34(4) is.
Yes. And when
Let us try tomorrow because it is at least from there to tribunal, not remand, from here to there. This requires a fresh consideration.
Yes, yes, yes. Milord can lay down the principles on the basis of which it should be reconsidered. 34 for my application.
In fact, not merely asking, but this adequacy,
exactly,
inadequacy is
adjudicated
to be looked into very carefully.
Yes, yes.
Otherwise, if I decide it, the other side will be losing, at least in this state will be losing another view.
Correct.
Let him decide.
Correct.
Let him decide, then the High Court can take another view. I'll try to.
Awards required to be dissected very carefully. So we can make an attempt. We can, different people may have different
No,
views.
34(4) is really a very touchy situation.
Very touchy situation.
1940 Act, there was the conditions laid down. These are
Yes.
the situations where the 34 like remand can be asked for. But
Yes.
here this situation has not been left. It's very open.
Very open.
Very open.
Very open.
loosely worded.
Let us supply her a copy.
Yes, yes.
Supply her a
Right,
copy.
What the kind of technology?
I go.
Get link. Site.
We filed it to party the first. Judgment section 24 file it. Next one.
I have marriage ceremony at my home today. That's why I wait for.
No, one thing missing. Just if you can come virtually, my prima facie view is it requires reconsideration. The learned judge possibly has made himself confused with the case of this general remand. If necessary, come virtually. My prima facie view is it should be remanded back to the court below for reconsideration of the application.
This matter was, your lordship heard them, your lordship was pleased to heard the matter earlier occasion. Last occasion, my lord, they have submitted a my lord report. My lord, whereon, my lord, they have stated, my lord, I got the amount, my lord, 14,468, my lord. No.
Huh? What is the matter about?
Their prayer is for disbursing of family pension, death benefit.
That is the matter, my lord.
Already we have submitted report that has been started. They are enjoying the pension, gratuity amount, entire gratuity amount paid, arrear pension has also been paid. Only provident fund that I have also submitted they have submitted the bank details last week. That has probably been also be collected by
For the disbursement of the provident fund, school authority is responsible. The school authority. You are the family. This is family pension.
Yes, your lordship. Wife.
Widow. This is teacher.
Yes.
So he died in harness.
Yes, your lordship.
So you got the other dues like gratuity, provident
Gratuity
fund.
amount, my lord, last occasion, they have submitted report, my lord, where I found the my lord, gratuity amount has been given.
Oh, you have received the gratuity.
My lord, may I, my lord?
Let us see what you have received.
Yes.
Provident fund you have received.
Provident fund, my lord, I don't know.
I don't know what your
My lord, this is the issue, my lord. The petition.
His client has appeared
Well,
before the authority. He should have instructions.
Yes, Mr. Ghosh, tell me.
Lord, the poor lady, my lord, her husband died in the year, my lord, 2001, my lord.
He was a teacher or was a group staff?
Teacher, my lord. Subsequently, my lord, the pension was initially, my lord, PPO in the year 2007, my lord. From 2001, 2007, nothing. 2001 PPO was issued and suddenly it was stopped. 1 month was given or not, my lord, it was stopped. Plus subsequently vacant, my lord, nothing. In the year 2019, my lord, I made a representation, my lord. Subsequently, that was not answered, my lord. I have come before your lordship. Before this honorable court, my lord, honorable court coordinated bench directed to dispose the application, dispose the representation. That representation was disposed of by the my lord, concerned DI, my lord. DI directed, my lord, I am not eligible to get anything. That order I have challenged, my lord, before this in this writ petition. At the time of writ petition, my lord, I didn't get anything. After filing this writ petition, my lord, they have started to pay me the pension. From that day, my lord, this is the report, my lord, your lordship also see.
So family pension, there's some huge area of family pension.
Yes, your lordship.
That is your claim.
Yes, your lordship.
That should be given to you with interest.
Yes,
this is
your
number one.
Yes, your lordship.
The gratuity amount possibly you have received.
Yes, your lordship.
The husband's retirement benefit means death benefit, whatever the death benefit, provident fund you have received.
Lord, that is not known to me, Lord, because the lady, my lord, this is the benefit of the circuit bench, my lord. The lady come before me, and before the approach before this court, my lord, for this, my lord, she getting something, Lord. He doesn't know anything, Lord.
Sure. Now you are getting family pension.
Yes, your lord.
From when you are getting family pension?
From 2021, my lord, I am receiving the pension, my lord. In the year 2021, they gave a lump sum amount of 14 lakhs. From the last 4 or 5 occasions, the coordinated bench of this honorable court asked them for a report that how that amount 14 lakh
has been arrived at, worked
yes,
out.
your lordship. That instruction was never given, my lord, whether interest was given or not.
sir.
Even in this report also, they have stated only 14 lakhs, my lord, given to me, my lord.
Report you have submitted when?
Last day, my lord. It was last, my lord, on last Wednesday, my lord. 6 December.
Oh. Your husband remarried.
Second time, the first one, my lord, first marriage was, she died, my lord. Subsequently, I got married, petition, husband married me, my lord. That document I have annexed, registered marriage.
Suspended PPO. Very well. Where I'll be getting that you have got 14 lakhs.
Lord, you kindly come to me, lord. Page 4, page 4, my lord.
Page 4 of our.
1, 2, 3, 4, 5, 6, 7, 8, number 8 column, my lord. Number 8, my lord. First, page number 4 of the report, my lord.
Report.
Yes, your lord.
Find out the report. এই বার করে দিন তো কোন রিপোর্টের কথা বলছি। Is a Bormon show the report? No, she report. Have you calculated a chart that since when this was paid up to this is then stopped, then thereafter paid this?
Lord, I could not, my lord, because they have given this amount, my lord. They are not giving, my lord, anything that how that amount come, my lord.
No, no. At least you know when your pension was stopped.
2000.
You know when the pension again started. You know when again re-stopped. I want that chart you should place before me. That after the death of my husband, the family pension was started on that day.
2007.
Then month.
Yes, my lord.
Then it was stopped in this month.
Your lordship also find it, my lord, in the report only, my lord. The next page, page number 5, my lord. We have also annexed the people.
Where from I will be getting the amount?
14 lakh, my lord, from 1, 2, 3, 4, 5, 6, 7, 8, 9, 9, my lord.
14 lakh 14,000.
Yes, your lordship. That
This
amount I
was
got
paid on when?
30th July 2021.
Thereafter, you are getting the regular.
Yes, your lordship. But
So whatever is done up to 2021,
yes, your lord.
whether this 14 lakh is inclusive of
Area-
all dues,
All the area pension. That
all
is in the-
area pension.
That is in the report also they have stated. At page 6, Lord. That is
Page
the detailed
6.
report.
Page 6.
Lordship. Last page.
Acha. You have received all area pension according to this report.
Yes, your lord.
Let us go by this. Unless you show You make calculation if there is any due, more due or not. The one thing is missing, whether you have received provident fund or not.
But I will take him. They can probably.
Provident fund, no, they cannot say. The provident fund amount is with the school authority. They have to take the steps, calculation to send. It is your money, your husband's money.
Yes, sir.
So that you take your steps. If the provident fund amount is due, you take up with the issue with the school authority.
Yes, sir.
Now the question of interest comes. So within, for that reason, this 14 lakh you have been paid on
2021.
2021.
Milord, even Milord in the story, Milord in the page number, Milord. Very, very.
Yes, but don't, lawyer never give.
Milord, he continues for 2 years to give this report, Milord, and now he is interrupting.
Now just tell
Milord,
me.
kindly come to page number 6, Milord. They are stating, Milord, that Milord, they are stating, Milord,
Received area pension.
the petitioner has been granted the PPO pension of payment of pension through PPO. She had received the pension from Alibudha Treasury from 1 month on 2014-12-2007 as per the report Treasury, Milord. Later that we stop, Milord.
So let us understand from January 2008.
Yes, your Lord.
Your pension was stopped.
Yes, your Lord.
And it was calculated at 14 lakhs odd. Again, again it started from
2021.
August 2021 it has started.
Yes, sir. 27 January 2021 started, Milord.
27
January 2021. Pension started before, Milord.
when?
27 January 2021.
21.
Yes, your Lord.
Then ADR pension was calculated, paid on August 21.
Yes, your Lord.
July 21.
July 21.
So from 2008 to 2000 August 21.
Yes, your Lord.
You are entitled to weekly interest.
Yes, your Lord.
That is your prayer.
One prayer, Milord.
And the other prayer.
But from 2000 to 2001 to 2007, Milord, that amount was not, no pension was nothing was given to me.
14 lakhs.
But that is the reason, Milord, I want to know that 14 how.
No. You calculate.
Yes,
it is
Lord.
your money.
Yes, well, I will calculate then, Milord. Then, Milord, like, kindly make next second, Milord. I will calculate.
The main prayer is already.
ADR pension paid, already been paid. You are saying whether it is all ADR has been paid or not, it is your money. You have to calculate.
But I will calculate, Milord.
Whether you require more, if there is any due or not.
Yes, Lord. I will calculate.
But one thing is clear.
Yes, Lord.
That is an admitted position that your family pension was stopped from 2007.
Yes, Lord.
Rather 2008. December, up to December you got it. From 14 December 2000 is as per report of the Alpur, you got it. Later on her pension was stopped, is in not know.
Yes, Lord.
Now from that 2008 till the entire bulk was paid. Again it was started in 2021.
Yes,
January.
Yes, Lord.
So this period you are entitled to interest for it.
As well as, Milord, how they have come to the 14 lakh.
No, it is your money.
Yes,
You have to get. You are pay.
Yes, sir, I will calculate.
You are asking money from him. You will not calculate.
Yes, sir, I will calculate. I will calculate.
So why you are keeping it pending?
Well, kindly keep it pending.
I am
poor
giving
lady.
you, listen,
Yes,
I am giving you liberty. If there is any due and payable, more due, you file a separate writ petition.
Grateful, Lord.
Ashok. The husband of the petitioner was an assistant teacher.
Yes, Lord.
Assistant teacher
Of
of
School, school.
which school?
Well, I am Milord.
Huh?
Yes, your Lordship.
Para 4.
School authority is not a party.
No, you know. Headmaster, yes, respond number 5.
Respond 5.
Headmaster Moddo কামাখ্যাগুড়ি ললিত স্মৃতি প্রাথমিক বিদ্যালয়।
Yes, as an assistant teacher of Modho Kamakhaguri,
কামাখ্যাগুড়ি
Lolit Smriti Prathomik Vidyalaya. Modho Kamakhaguri district?
District में अलीपुरद्वार now.
District Alipurduar.
Well, he's the head teacher, my lord.
Headmaster?
Head teacher.
Head
Your lordship.
Is it assistant headmaster of such and such? Stop. He died. Who died in harness? Stop. The petitioner being the widow of the deceased teacher. Acha, when he died?
In the year 2021,
Who died in harness on October 9, 2001. The petitioner being the widow of the deceased teacher started receiving family pension, but all on a sudden, such pension was, payment of her such pension was stopped. The petitioner has filed instant writ petition praying during the pendency of the writ petition.
yes, your lordship.
What is your prayer in the writ petition?
The prayer is not, my lord.
They are to disburse the family pension and death cum return benefits, including the arrears, as well as interest in favor of.
For payment of arrear and current family pension and disbursement of other death benefit of her husband. Stop. Mr. Ghosh, learned advocate for the petitioner, submits that during the pendency of the writ petition, the family pension of the petitioner. Now, the petitioner again started receiving family pension from January 27, 2021.
Yes, your lordship.
And on July 30, 2021, a sum of rupees 14,14,468 was paid to her on account of arrear family pension. But the petitioner is not sure whether the said amount, whether the amount so paid is the entire and total due family pension or not. It is required to be calculated. Stop. The gratuity amount, as admittedly, has been paid to the petitioner. Mr. Ghosh is not sure about the payment of the provident fund amount.
Yes, your lordship.
So, Mr. Bormon, appearing on behalf of the state, submits that the grievance of the petitioner has already been resolved, as the family pension has started and arrear thereof has already been paid. It appeared, having heard the learned counsel for the parties and on going through the material sorted for it appears that the district inspector of school, no, sorry, sub-inspector of school Alipurduar East Circle, District Alipurduar, has filed a report in this case, in the matter on December, affirmed, which was affirmed on December 6, 2023. And from the said, from the annexure to the said report, it appears that a report of the district inspector of schools PE Alipurduar, the respondent number such and such herein
Respondent 4.
forms part of the said report. Appears from the said report that though the family pension of the petitioner was started from though the family pension to the petitioner was though the petitioner received the family pension from Alipurduar Treasury for 1 month on December 14, 2007. Thereafter, the payment of such pension was stopped for unknown reason. Be that as it may, the stop of pension or stop payment, the pension, family pension, payment of family pension was stopped. The reason of stopping the payment of family pension is therefore unknown to the authority. The petitioner cannot be made to suffer for such delayed payment. She is entitled to interest on the arrear pension. The district inspector, the respondent number 4 therefore is directed to take steps for payment of interest at the rate of 8% per annum, 6% per annum, from the date when the said family pension was stopped and to the date on which the arrear amount of family pension was paid to her. Respondent 4. Stop. The said respondent shall complete his treat in this regard within a period of 4 weeks from the date of communication of his order, and shall thereafter take forward steps accordingly. Disposed of.
Hello, one line maybe attended.
The petitioner is at liberty to take up the steps for payment of provident fund amount of the deceased teacher if it is not already.
Another thing,
the petitioner is claiming from pension from 2001, my lord. So, my lord, according to their statement, my lord, they have calculated from 2001, my lord. But I have to calculate and can, if many year comes, my lord, then I have to come with it.
Acha, if the petitioner is also at liberty to lodge further complaint in the event if it is found that that the amount already paid on account of area family pension is inadequate, is inadequate. Lodge your complaint. What is the use of keeping this writ petition pending? Come with a fresh one.
Before the appropriate authority. Before that.
Yes.
Kindly, my lord, that was.
No, don't lodge this claim before Mr. Borfon.
No, I will not.
Will not pay it from his pocket.
The kind DI, my lord, I have to lodge a complaint before DI, my lord.
What? ঠিক আছে, ওই respondent number কি? Lodge formal respondent number
4, my lord.
4.
Grateful, lord.
Next one. Who is showing this? Nice music. Can you play it again?
My lord, I'm for the School Service Commission. I'm appearing online.
Yes.
My lord, I am for the petition.
Yes. What is your case about?
Well, that tampering of marks.
The original, with leave of Miller Dr. Patro, the original affidavit has been affirmed. It has been dispatched by post. But the hard copy, Miller, we are yet to receive. I have the scanned copy of that, the affirmed report, if Miller kindly considers.
So what is the matter about? Tell me.
But my lord has given direction upon the Central School Service Commission to furnish a report regarding that tampering of marks can be done by the scrutinizer or not.
Two sets.
Yes,
Yes, one by signature by the evaluator and signature of the scrutineer.
yes, ma'am.
So you are saying these are the scoring through is made according to Dr. Patro by this by the scrutineer. Who is coming first, evaluator or the scrutineer? Dr. Patro.
First the evaluator checks.
Evaluator
Then it is
scrutineer. Now this is scrutineer which has been done over here, and it is permissible under the. You get the copy of the report.
Yes, my lord. I have received the report
So if
today.
you are accepted, then and
No, my lord.
you want to file an exception, file an
No, my lord.
exception.
I'm just placing my submission on the basis of their report only. My lord, has the copy.
No, just tell me.
My lord, in this report, their annexer R1, my lord, page 8. Serial number 10A3. Checking of marks of each answer and its posting in the top sheet be done by the scrutinizer, and she be authorized to make correction for any overmarking, undermarking to any answer if so required. My lord, I just want to know what this means, top sheet.
This top sheet is this.
Where the total marks.
Then are you suggesting in the inside he cannot do that?
My lord, no, my lord. If that is the case, my lord, that only the scrutinizer can give the marks on the top sheet.
No, he can reassess.
No, my lord.
Mr. Ghosh, give me the copy. Yes, ma'am.
Kindly read, my lord. Very specific it is.
Page
8, my lord. Page 8, serial number 10A3. A3.
It is clear. He can make this correction.
My lord, yes, I'm explaining, but the top sheet has to be marks has to be given by the scrutinizer on the top.
No. Checking of marks of each answer and its posting in the top sheet be done by the scrutinizer.
What is the meaning of that, my lord? Posting on the top sheet.
Dr. Patro, what Mr. Shantanu is saying, Mr. Shantanu is saying that if you bank on this 10A3, checking of marks of each answer and is posting in the top sheet be done. Therefore, the posting must be done by the scrutineer only. Is it the meaning also?
The posting is done by the evaluator. Now, if the scrutineer while checking, if he makes any alteration, then that is also to be posted on the top sheet.
That is not.
That is the procedure. All examinations, the top sheet is always filled in by the examiner and signed. That is why the box for signature is at the side for also the evaluator. But what I was submitting is that we need not go into these arguments, because kindly in the sub-paragraph 6, we have written that this matter is the subject matter before the division bench. The coordinate bench has held that the scrutineer cannot alter the marks. Against that, we have filed an appeal that we have clearly stated in our affidavit. So let the division bench hear it out. It is running in the list. It has already been heard on several occasions.
Then hearing cannot be done at this stage. Where have you stated that?
My lord, page 4, sub-paragraph 6.
Ashun, লিখুন। The Mr. Ghosh, get the affirm copy.
Yes, it will be.
And file it in course of
this week. Okay. I don't know that it can reach me today, tomorrow.
We dispatched it on Monday by courier. It should have reached, maybe it will reach today or maybe latest tomorrow. I will inquire.
Kindly take the file of this pile, item number 13, my lord. I want to show that the difference between both the candidates, what the scrutinizer has done in both the cases, my lord. They are different, my lord. In item number 12, no initial was put in the answer script. In item number 13, my lord, there was initial of the scrutinizer. So my question is whether, as per my knowledge goes, if there
whether
is
it
any
was
cut,
done, whether it was done at all by scrutineer or not. Yes.
because as per my knowledge goes, my lord, if
No, Dr.
any mark
Patro,
is cut, you
Dr.
have to
Patro,
put initial.
Dr. Patro, therefore, the challenge is not to that. The scrutineer whether can do or not do. The challenge is whether scrutineer at all has done it. Because in this case, no count. There is no counter signature.
No, maybe inside there is no counter signature. But this inside, maybe there is no counter signature. But on the top sheet, he has put the signature. And the marks which are on the top sheet are tallying.
No, Dr. Patro. In another matter, what
Item
he is
number
saying,
13, my lord, 2.5 marks has been cut.
wait, marks is not. In another matter, what he wants to demonstrate that the scrutineer who has reduced the mark or enhanced whatever, he has put his signature, counter signature to that. Now, first of all, in any event, whether route permits or not permits, any correction must be sanctified or must be attested by a signature that I have done it. Now, what is the effect if it is not done?
No, may I just submit this?
Now, make
the
it
examiners.
First of all, he is not questioning that scrutineer cannot make this. Scrutineer can make this. Let us proceed from that. Yes. But whether
then also let that be recorded that he has accepted this proposition.
I will be
that it can be done.
That whether
now the signature part.
No, Dr. Patro, in this case, you are required to take a specific instruction in respect of this answer script. That whether the scrutineer was right in not putting his counter signature in each of the Then now supposing a case where he has reduced it, where is the number?
My lord, kindly take up item number 13, my lord.
No, in this matter, where is that?
Page 51, my lord.
Page
51. 51. It starts from page 51.
No, where is the scrutineer's marks it has been scored through? In which page? Now supposing page 67.
67 and 68.
67, 1 is reduced to half. 68, 1 is reduced to half. But there is no signature. What is your response to this?
My lord, my response, I will file the affidavit if necessary. But what I was trying to submit is.
Where have you
that-
alleged that it is there is no counter signature in your writ petition? Where have you stated?
My lord, I have
You must have, the allegation must be specific.
yes, my lord.
That I am not challenging the authority of the scrutinizer
My lord,
to reevaluate the number. But my challenge is that when this revaluation is not countersigned by the person who has done it, so I have every reasonable doubt this has not been done by scrutineer, by somebody else. That is your case?
yes, my lord. I have challenged my writ, my lord, the tampering of marks, and it has to be, I prayed for investigation by an independent agency, my lord.
No, forget
That is
about
my
that.
prayer,
The base
Now,
of your base.
when they are coming up with the affidavits wherein they are categorically stating that it can be done, there the question arises, if it is done, then where is the initial? How could we ascertain
No.
whether the scrutineer has
First of
done or not?
first of all, you must be sure what is your challenge.
My lord,
If your challenge is that the scrutineer has no authority to reevaluate the number, then you have to wait for the decision of the
my lord.
division bench.
Second,
If-
my lord, second thing is,
Are you accepting that a scrutineer can evaluate?
no, my lord.
You are not accepting that. Then you have to wait.
Because, my lord, on the top sheet, as per their claim, on the top sheet, the scrutineer is only authorized to put the marks.
Mr. Shantanu, the challenge, if you challenge that scrutineer has no power to evaluate, then you have to wait.
Lord, even, my lord, if he has put the marks on the top sheet,
No, this
he
is
has
not
got
all.
his own marks. He has detected his own marks, my lord. If I go by their statement, kindly, my lord, come to
No. First of all, don't go here and there. First of all, tell me whether you are challenging the authority of scrutineer or not.
yes, my lord.
Then
First,
go
my lord.
wait.
Second, my lord, the initials.
If you challenge that, then you have to wait. Then you take the other grounds.
My lord, then kindly that challenge of this signature, presence of
Where is your state pleadings?
because they came up with an affidavit.
Then
let me come up.
No. You know very well from the beginning that these are the grounds. Scrutineer cannot. Secondly, even if scrutineer can, the number is not been countersigned. The corrected number has not been countersigned by the scrutineer. Where have you?
Allow me to file exception to this. Then I can come up with that.
Very well. Ashok. The report as
My lord will kindly record. My lord will kindly let the matter stand over till the decision of the division bench.
Yes, hear
and
it,
let
hear it.
exception come in the meantime.
As directed by the order dated December 7, 2022. Now, the scan copy of the report. Is filed on behalf of the West Bengal Central School Service Commission. Mr. Ghosh, Dr. Patto appears virtually on behalf of Commission, and Mr. Ghosh appears physically. Patto appears virtually, and Mr. Ghosh appears physically on behalf of the Commission. Mr. Ghosh undertakes to file the uh, the report. The original, the affirmed report in course of this week, in course of this week. So, Mr. Shantanu raised leave to file exception to this aid. The commission in its report has disclosed that the that a similar issue, the issue which is under consideration in the present petition is pending consideration before the Honorable Division Bench. So, in view of the pendency, in view of the course, so in fact, the hearing of the writ petition is adjourned till the decision of the issue by the Honorable Division Bench. Exception to the report in the meantime. Liberty to mention.
Deeply obliged.
12-13-2.
Action. My lord, in 13, my lord, they are yet to file the opposition.
Opposition or report?
My lord, no, my lord. The first order was of Justice Krishna Rao. He directed them to file opposition, my lord.
Dr. Patro, item number 13, opposition.
But on the last occasion, it fell from the court that I will file one report which will cover both.
Both.
But the opposition was filed.
Was filed already?
Yes. I will check with my junior and request him to serve if it has not been served.
But we'll do the needful if it is not on record. I believe it was affirmed.
Already affirmed.
Yes, এটা কি?
Opposition done.
I'm just checking.
That kindly extends the time limit by 1 week or so that we can.
এটা পারমিতা বাবু? My lord, the draft copy I could find, but the affirmed copy I'm not managing to locate. I will check it and I will send it. Just give 1 week's time.
Dr. Patro, learned counsel for the commission, prays for extension of time to file, to affirm the affidavit in opposition, to file it. Affidavit of praise, praise time, special time for 7 days to file the affidavit of opposition in terms of the order dated June 13, 2023. They are allowed copy thereof is served. Copy of the opposition is served upon Mr. Shantanu, learned advocate for the petitioner. Stop. Reply to the said affidavit in opposition will be affirmed by the petitioner within a week from the date of receipt of the copy of.
I'll make it 2 weeks.
2 weeks from the date of receipt of the copy of such said affidavit in petition. Matter be listed before the available circuit bench on completion of affidavit by the parties. Next one.
Only one thing on the last day it fell from the court that the report which I'm filing today will cover both the matters. But still, I will file the affidavit since there was a
file
delay.
it because the report you have filed, let it be on the record because the point is now has been pointed. The only thing you are required to take instruction from your client why this signature is missing.
Yes.
Deeply obliged.
In 14 Millard, I am praying for Millard next circuit, Millard, the necessary addition of party and Millard service, Millard could not be done.
Sir, most learned counsel for the petitioner. Please that the matter may stand over to next circuit, next available circuit as necessary, as he could not take necessary steps. Prayer allowed, prayer is allowed. Next. Next one.
I'm for the respondent.
Millard kindly takes the last order, Millard, this is regarding Millard to land acquisition process pertaining to a tea estate. Millard, wherein we have said that the valuation of the shade trees and bushes as has been done is inappropriate. No money has been received till date. There is a dispute regarding the quantum of that. Now, Millard, if Millard kindly takes the last order, Millard, the competent authority, that is, Millard, the special land acquisition officer was directed to send the estimate to the national highway, and the admitted amount was directed to be paid. Thereafter, Millard, we don't know what has happened.
As per instruction I have received, the competent authority has submitted their estimate on 25th August 2023.
When?
25th August. Subsequent to that project, we have again prayed for the revised estimate, Lordship, but now the department has decided to challenge that estimate under section 335, Lordship, because we are not agree with that estimate, Lordship.
Where is the estimate?
We have already supplied to.
We have received, Lordship.
They have to deposit the money to the.
We are aggrieved of the
Estimate understood, but what steps you have decided? Decision will not do.
No, Millard, even this submission, Millard, is absolutely untenable that it can be challenged because Millard kindly turns over to page 62. They have, the competent authority had sent the estimate back in 2016
but
with the quantity. You did not challenge this.
This amount.
Yes.
Now they are agreed that they are possibly the bushes and tinches had not been taken into account.
No, it was taken into account. The dispute is regarding applicability of the rate. At what rate it should be the estimated.
We are following that.
Now the competent authority, for good, bad, indifferent reasons, has arrived at a particular amount in 2016. Pursuant to this estimate is issued pursuant to an award. Millard would also find the reference of the award at the top. LA case number so and so, date of notification.
Pay this amount.
Yes.
Lordship, we are agreed to pay this amount, but in hand.
We are only claiming this amount. We are claiming this amount only as of now.
No, Lordship.
The enhanced amount, the estimate.
Yes.
Which was made subsequently.
No. Initially, the awarded amount is 6 crore. We are disputing because the.
This is 6 crore.
We are disputing this amount, Lordship. After the order of 16th August, the competent authority again sent a revised estimate, which was at.
No, not within our knowledge. Millard, it has to be borne out from records.
अरे दिखाओ ना आप लोगों को तो मिला है.
That is reminder.
That is a reminder. We know it was, the reminder was sent.
25th August, Lordship, of press
Mrs.
estimate.
C, come to page 6.
Page?
62.
62.
Yes.
What is your comment on this?
Lordship, after this, we have wrote the letter to the competent authority because they ascertained the amount as per the arbitral award of 2016. But we say that the notification was issued in the year 2011, and the 3D notification was in 2012 and 13. We agreed to pay at the amount of 3A notification and 3D notification, not the arbitral award ticket 2016. That's why we are now decided to challenge this estimate, Lordship.
I understand, but wow, this
We are
2016 now.
agreed to pay as per the 3A and 3D notification, Lordship.
You never challenged this.
We have not
But
challenged.
subsequently order passed in 16th August 2023, Lordship.
16th August?
2023.
Where is that order?
16th
the
August
record.
2020.
In the court, Lordship. Passed by Honorable Justice Vijit Gangopathy.
No, 18th August 2023.
Yes. Subsequent.
There, being the special land acquisition has not sent any fresh estimate despite 4 letters issued by the
Yes.
NHI. You
Yes,
invited the fresh.
Yes, we have
Estimate.
invited the press estimate. Subsequent to this order, the competent authority on 25th August 2023, they have filed a press estimate amounting to ₹6 crore. Again, same, no change, Lordship. Then now we have decided to challenge that estimate,
The
Lordship.
cause of action of challenge.
Cause of action start from the
No,
16th.
cannot.
You have taken advantage of that.
Yes,
You cannot
yes.
do that.
Yes. You have kindly record
This is
cannot be done.
his writ petition. You have used it in your benefit.
Yes.
No, Lordship, in four letters, National Highway Authority wrote to the competent authority
But
to
writing will not suffice. You have to go by the statute. If you have not challenged it, that amounts to acceptance.
11th August 2016.
What?
11th August 2016.
2016.
Estimation was again, he was directed to re-estimate at the higher side, not to the lower side, I suppose.
No, Lordship. We are agreed, Lordship.
Because it is
We are
their
ready
writ
to pay
petition.
as per the 3 and 3D notification.
It
Not
is
for
their
that.
writ petition.
Yes, Lordship.
It is not your writ
Like
petition.
yesterday, Mr. Basu showed 1971 Supreme Court, requiring body cannot be agreed. They are the requiring body. 1971 2 SCC. If required, I will place that.
Pay money. Everything is done.
Yes. You have not challenged it in 2016, now you cannot raise a dispute.
At least you have to pay this amount.
Yes.
You prayed for reassessment.
Yes.
No,
Then
he
what
has
side?
not-
No.
I paid for
My
reassessment.
grievance in this writ petition is non-payment of amount. Non-payment. I am
How
happy
is
with this amount.
question of reassessment coming?
No, doesn't come. I am happy with this amount. You pay this with interest. I am entitled
Where
to
is
this.
the challenge?
We have objection because the amount the Kali.
Where is the objection?
Lordship, after 16th.
You have a recourse? You have a recourse to challenge it?
Had
Yes.
Had a recourse?
Still I have, Lordship. Still we have, Lordship. Still. Because the order press.
Pay,
estimate was passed on 25th August,
otherwise, who is the disbursing competent authority, disbursing authority?
Let the project director, National Highways, the requiring body.
Ask him. I will attach his salary.
Grateful.
Ask him. This payment is to be made. Nothing. You have played along. And you have used this order of Justice Gangopathy to your favor.
Lordship, before this order,
Yes.
we wrote to competent authority 4 times for reassessment.
Writing will do, or you have challenge is essential. There is an award.
Yes.
You have not challenged that award. You have not referred to this arbitration, all these
Yes,
things. You did
yes,
not
yes.
take recourse of that.
Yes.
You have to abide by this. Make this NHI authority understand. Why don't you bring it the first day? Why don't you bring it before the first day? Ask this, who is this project director?
Where is the
Respondent number
project
5. I'm giving you 1 day time.
Grateful.
I'm giving you 1 day time. Come clean. Either you make payment or give undertaking. Within this time, I have to pay. Otherwise, he has to face the consequence. He's personally, he was the authority for payment. Take instruction, come tomorrow.
Lordship, day after tomorrow, Lordship.
Marriage.
Already Asian Highway marriage speaks lot. There is not. Already Asian Highway matter speaks Lordship. I have a marriage at home tonight, Lordship.
So by tomorrow it will be over. Similar,
पढ़ना भी तो-
it's only about taking instructions. You take instructions and come back.
I have to pay.
Tomorrow by 2 PM. Let us have it. on-
Reassessment. What is the use of reassessment?
Nothing.
Why-
We are happy with this amount. We are happy with
Why
this
then
amount.
you have invited the court to pass such an order that reassessment should be done?
Milord, a confusion was created before the court.
You have become greedy to get more.
No. Kindly see my prayer. I cannot go beyond that.
So why you have invited the court to send the reassessment?
Confusion,
Where is the question of reassessment?
no.
Unless the arbitral award is set aside, the it is followed by an arbitral award.
Yes.
Accepted by the parties as of today. No challenge to the award. What was the award? Where is the award?
Milord, kindly sees, Milord, 8A, total amount of award, 59.
8A.
Milord, 8A, item number 8A. and
Where is the award? Mr. Ghosh, copy of the award you must have been with you.
Milord, this is what has been supplied to me as the award. And we have
No, cannot be. Where is the award?
Milord, apart from this, Milord, nothing has been made.
Inquire. Where is the award?
Milord, at page 59, Milord would find the estimate which culminated into that award.
I understand. Page 61.
Yes.
You are requiring body, you have to pay. You are enjoying the property without payment.
You want to pay
Where
but
is
as
that?
per.
You have no challenge. Award of which date? Award passed when? This was the estimate sent to you by the acquiring body. Huh?
Milord would find 8A says total amount of award. So, Milord, though it is wrongly, Milord, worded, it should be treated as the award. Because as we understand under the 1996 Act, printed on 50 rupees stamp paper, a publication of award, Milord, that is not being done in those cases.
You have not inquired about it. You are only after money. You should have.
Milord,
You have asked for the breakup.
Yes.
Therefore, you must have been aware of the award. Thereafter, you asked for in RTI about the breakup from NHI.
Yes.
So inquire from your office whether the award has been communicated or published.
It's not published.
No, I will challenge. We have decided to challenge. We are in mind of challenge. We are thinking the challenge. We are meeting each other with cup of coffee and cashew nut.
No,
That we will be challenging
as
it.
per
No,
3G1, Lordship.
I am not going to. I am not going to.
2 minutes more, Lordship. The competent authority submitted 3G1 estimate. Then we have a right under section 3G5. If the amount determined by the competent authority under subsection 1 and subsection 2 is not acceptable to either of the parties, the amount shall, on an application by either of the parties, be determined by the arbitrator being appointed by the central government.
Please.
If now our right established from 3G5.
Please give it.
Milord, page 70 is Milord the award. 70. Award note.
The award must be.
তোমার অ্যাওয়ার্ডটা প্রডিউস করো না, তোমার রেকর্ডস আছে?
What? There is no award.
Because we want to challenge under section 3G5,
No.
Lordship. They have submitted 3G1. Now we are.
No, the 3G1 submitted when 2016.
Yes,
2016.
3G1 submitted. First 3G1 submitted.
Submitted.
Yes.
2016.
Yes.
Then, when you have raised your objection?
When 4 letter issued to the.
When? The first letter?
26th May 2017.
I submitted on last occasion, Lordship.
Steps under subsection 5 of 3G when taken first?
No, not
No
taken.
steps taken.
have said, we are not agreeable, refer it to the arbitrator.
Yes.
That
We
letter you have
requested the
received. when?
competent authority to revise their estimate, Lordship. We wrote a letter to the competent authority.
So this
They
is not a
refused-
5, they don't know the 5.
No,
Where is it?
No, no, we have not challenged under section 5.
5, 6, 3G1, you are not agreeable to this estimate.
Yes,
Course is 5.
yes,
Instead, you are asking them to
revise.
revise. Where is
Yes.
the scope? Where is the scope? Where is the scope? Where is the scope? Payment is only way out. 3G1 estimate sent. You are agreed, you are not agreeable to pay this amount requiring body. Recourse is 5. Send it to arbitrator. Now what? If you instead you requested revise the estimate. They don't have any right even to revise it.
Yes, if I may, let's just note this. Under the statute, the expression used is determination. Neither it is estimate nor award. So once from any document, if it transpires that a determination has been arrived at, 3G4 is over. 3G5 starts. The applicability of 3G5 starts.
Then what is a award about? Is
So-
there any reference to?
Willard-
I was under the impression this part has over.
No.
Then the award note.
The award note is for the entire Moja, but this is what has been communicated to me.
This
The
is the LA award. This is the LA original award.
original award.
Original
Yes,
award.
yes. But in my
It
case,
is not the award of the arbitrator.
yes,
No.
no.
Payment, take instruction. Otherwise, this, who is this, to whom you have addressed? You have sent his
Project
estimate.
Project director.
The project director has to let him not to take salary for 1 year, 2 years, so long it is not paid. This is
Great.
cannot be done. You have exploited already you have done so. And 5, now you will be sending it that after 5 years, 6 years, you will be sending it to the I'm agreed by the estimation. I want to take the course of 5.
That also will not on my writ petition being made.
You have invited.
Let's say it will come up tomorrow. Tomorrow 2 PM let it be there, subject
I
to
don't
your
know.
convenience.
I don't know.
2 PM.
With this showdown head, she cannot enjoy the marriage ceremony.
Already,
Well, let the project director face the sword.
Lordship, I have decided I'll not go to marriage.
No.
No,
That I will not.
Highway matter is very difficult for me.
Very well. Only 1 or 2 matters on Friday. This is one of the
Great,
matters. Friday. No. Yes, Mr. Majumdar.
Lordship, we have for the respondent.
Yes, what is your report about?
Lordship, so far as the army is concerned, grave is concerned, we had paid the whatever the estimate that was handed over to us by the state somewhere back in 2010. Last payment was made in 2011. We do not know what the state did when the state disbursed.
Money, where has been siphoned?
Forest
Fixed deposit.
We had paid in two heads, around 2 crore plus something for the land. And forest, we had paid to forest for removal of trees for around 1 crore plus. So, my lord, I am praying that as my learned friend pointed out, forest department may be asked to appear before the honorable court and state what they has done with the land.
The entitlement is
For the petitioner, yes, neither you nor that we can do that.
Who is for the petitioner?
My lord, Mr. Subba generally addresses the court virtually, but today he is not there.
Can I wait for tomorrow? Any junior officer Subba is not here.
Because oh, তাহলে আমরা তো কালকে রাখবো। My lord, because to keep it cool, my report is also on the way from the special LAO. That's sensitive.
So it is understood the land of the petitioners have been taken.
Most likely, and GRE has done the work. Now, the question that what I have been informed verbally is that there has been no acquisition.
How you have taken money from them?
We have paid. No, direct. There is a specific LA case. The specific LA case. That is with respect to part of the, not an entire. My lord, it was happened in 2010. We waited for 2 years. They gave us clearance to use the land. Then we went on the project. The money has not been paid. That is admitted fact. The money is still lying with the authority.
No, this is not the case.
Page 16 years. Daily case number 7/4/2019.
Page.
Page 16 years. My
Annex to R3.
I have not been served with a copy of it.
Yeah, this is for the collector, actually.
Yes, Then page 11, we have paid the amount as per their
2009 and
19. তারপরে স্টেট পাঠালে তারপরে সেটা পেমেন্ট
The LA case award has been published.
And that come with the lordship at that juncture there was no direct purchase.
No direct purchase.
My instruction is on the way. Let it come tomorrow.
Don't file it today, come tomorrow.
Grateful, my lord.
meeting করব আগে সাথে আগে
Yes, my lord. Mr. Jana is appeared.
Report. DI report.
So in this case also another problem, Mr. Bose is with me. She has calculated her marriage is fixed on
Marriage of
council.
The report, I tell your lordships, it has been settled by your lordships, also division bench. I have annexed the division bench judgment. Part 1 examination before joining was completed.
Mr. Jana.
Yes, my lord.
You are invited to a marriage here. Marriage of the opposite parties council. Would you like to come?
Then I can.
Which boss is?
Oh.
He's a state advocate. Convention is paid for. On behalf of the what is that full name? As the marriage ceremony, as a marriage ceremony. Tomorrow. Matter be best before the next available.
আমি দেবো আপনাকে বলে দিয়ে দেবো বিকাশ
Lordship, Mr. Subba, he will appear virtually, Lordship.
No, tomorrow morning ask him to that his report is on the way. Next.
18.
18 million I am playing for next year. The service is not complete upon the added purchase.
No, 18 is different.
19.
My lord, is the mother claiming the
Family pension where the wife is being paid. Widow is being paid.
No, 18, there is a direction to settle the issue by a mediator.
First, directly to send the
Mediation.
the matter went to mediator.
Mediation report is not available. Who was the mediator? Sudipto Bhumik.
Yesterday, mediation failed. Report is not available. Report I have.
Where is Mr. Bhumik?
Mr. Bhumik is not. Mr. Mishra is the petitioner.
No, the mediator.
Well, she's there.
রিপোর্টটা দেয়নি কেন এখানে? আমার কাছে তো নেই। দেখুন তো রিপোর্টটা আছে কিনা? এই তো।
And another thing, Mr. Jagriti Mishra is appealing for the petitioner.
Oh no, flag is available. Sorry.
And he requests to can you take up the matter tomorrow? Mishra is not available.
This is successfully done. Successfully done. Mr. Jana, you are aware of this the
Yes,
mediation report?
We have gone through the report. Only one melody submission before loss. Melody second page. Melody respondent second page your loss you can receive serial number 1. The respondent number 6 hereby relinquish her claim of 50% of the family pension in favor of the petitioner with effect from this day. Melody normally DI asks melody no objection by an affidavit by the notary public. Melody your lawsuits melody direct the melody petitioner to give an objection by an affidavit so that the melody I melody relinquish my family pension 50% of the family pension on and from the month of January 2024. So
No, required steps will be taken up by the parties before the concerned district inspector also.
That's
I'm not on the point.
that your lawsuit direct on the basis of mediator.
Tell me how this 50% can be secured.
This is my lord's order.
No. Secured means it will come from you or directly from DI to the account of the petitioner. Can it the family pension be split up in this way?
No. That is the
cannot be. Therefore, it
the
goes to the respondent number 6 first. Then the respondent number 6 will pay 50% of it. So
I can provide melody from my pension account.
Yes, there lies the problem. Because the pension amount cannot be split up. After coming this money, you have to give it month by month to the petitioner, to the respondent. The mother-in-law is to the petitioner, your client.
Yes.
How can it be secured that every day, every month you will be paying that? If monitoring is not possible, find out a way.
No, if let there be a judicial order, then I must be complied with. Melody, your losses melody provides the bank account.
Neither you nor Mr. Kundu, no one can get this. 1 month
I am with Mr. Jahar.
Yes, therefore, both of you I'm telling you, you cannot have
Mr. Jagriti Mishra. Petitioner is not.
And his presence is necessary.
Yes. Over telephone, Mr. Mishra.
What?
Over telephone, Mishra requested him to not to get it.
Don't pile up. I will not be able to take on the last day. I'm telling you with very. I'm coming back within 5 minutes. There is no recess.
That national highway matter, Lordship, can they keep it tomorrow, Lordship? Because we will not have visible.
ন্যাশনাল হাইওয়ে যে ম্যাটারটা কালকে রেখে দিই।
হ্যাঁ হ্যাঁ হয়ে গেছে
Oh, acha. Yeah, you have made a very, thank you. It's a very successful mediation. And these are the cases where there is no way out. Legally speaking, this cannot be done in this way. So we have to find out how the family pension will be shared. Because the DI, not the authority, cannot split out it. A person who has not entitlement to receive family pension, a portion cannot be given to her. It is up to the person who is getting it after receiving he will be shared. But how it can be secured?
But the lady is not unsure about the agreeable. Oh, that is the egoistic problem. I will not take it from him. Let DI be director. I cannot do it.
DI cannot do this. Just for the respondent.
Yes, I am. Daughter-in-law.
And the petitioner is Mr.
Mr. Mishraji, Jagriti Mishra.
Let him come.
Yes.
Let him come.
Yes.
He got person. Yes, next one.
Okay. And
Thank you, Lord. I'm praying for next service. Note of the added respondent service is not complete.
Service is not
They have
already
present. না একজন তো কোথায় একজন আসছে ও একজনকে দিতে হবে।
What is this matter about?
Milord, that road transport permits
Timetable.
timetable where Milord was pleased to Milord direct that the persons who have been granted with the fresh timetable should also be added as a part.
What is your cause of action?
Milord, my cause of action is I am the association representing not only the bus owners of that route, but I also, some of the members of the association owns their own buses. I say that the discretion to allot new time slots cannot be an uncanalized discretion. It has to be based on particular facts and circumstances, one of which is profitability of the route and the number of buses already running. Now, I say that in that particular route, already in a time gap of 12 minutes, there are vehicles available, flying. Therefore, this allotment of fresh timetable is absolutely unwarranted.
Fresh timetable for 3 new buses.
Yes.
Not insertion of a 3 new bus.
Yes, new route permits have been issued. Seven.
So
And Milord,
can you regulate the number of buses we will be plying in a particular route, you being the association?
I cannot, but once the authority who is regulating and exercising powers under the Motor Vehicles Act, it's a discretion.
No.
How many route permits in a particular route I shall grant?
So there is no statutory limit?
No statutory
limit?
No statutory.
So the authority has decided to allow 7 more new buses thus permit to be issued in the same route.
Yes.
You, the association, it will reduce my profit.
Yes. Not only reduce, Milord, Milord, I am saying that that route
issued by the respondent.
Milord, it's a
Regional
route,
Transport Authority.
Milord, it's a route from Alipurduar to Sankosh, not a very heavy route. In that route, already 79 buses are planned. Where is the requirement of further grant of route permits? And Milord, I am covered by decisions. Milord, I am covered by decisions which shows that this power of the RTO exercising under the Motor Vehicles Act read with the rules is not uncanalized. Any decision to grant of new permit or alteration of permit has to be based on cogent materials and an inquiry or any other.
They are actually, the petitioner challenge the annexure P4 of the writ petition.
Yes.
Page number 30, my lord. And this is not relating to not route permit, my lord. This is the timetable which was provided by the RTO, my lord, Regional Transport Authority, because we are applying for them before the RTO for the.
So route permit you have already obtained. This is not under challenge.
This is not under challenge.
The challenge is only the timetable.
But can we see the flying on the road due to their timetable? Henceforth, the timetable annexure A has been issued. My vehicle is serial number 7.
So the timetable usually be prepared by the association.
No.
Yes.
Yes. It is the absolute domain of the concerned RTO.
RTO.
And rule 119 is speaks that it is final.
But Milord, records show that all this while, since 1980s, whenever route permits were granted, NOC from the association was called for a particular timetable. Though that do not have a statutory basis.
Yes, whatever.
Yes.
You are agreed by the timetable provided to 7 these are new buses. They are
Yes, new buses.
Means there is replacement of buses which are more than 15 years old.
That is Milord out of record.
Now, in case of dispute in respect of the timetable for a stage carriage on a route or area, the decision of the transport authority. Now the dispute, there was before any dispute being raised, was it has been timetable has been fixed.
Yes.
Now there is a possibility of adjudication of a dispute by the transport authority. Since they are raising a dispute, let this dispute.
So what not their timetable, so what the timetable are to other buses.
The new buses. for which new route permits have been granted recently.
It's not their case that their timetable
Now,
has been changed.
No, no, understood. In the route Alipurduar to Shankhosh, these members of this association are also plying their buses.
Yes.
They are agreed by a timetable fixed by RTO for new 7 buses.
Yes.
Right?
Yes.
Rule 119 says where there is a dispute with regard to
No, there is no.
all dispute in respect timetable. Decision of the authority is final. Now this is the decision, not after the dispute.
Decision, I have a inspection also. Can I go to inspection?
Whether there was a
I have an instruction wherein it says that there was decision. The possibility it is decided, other statute is decided by regional doctor already go. There was a decision and thereafter.
No, decision on a dispute being raised.
Yes, they were called, they were heard.
Oh, they were called, they were heard.
And final decision is to be taken by, there is no scope for their raising any dispute of the timetable which will be decided by state.
That's why, Milord, we are before your lordship that discretion cannot be uncanalized discretion.
In other case that their timetable has been changed. They are enjoying the usual timetable which was allocated.
Mr. Ghosh,
Milord,
the rule 119 permits that have you ever got any opportunity to raise this issue before the regional transport authority?
No. The association was called. I have, Milord, annexed the notice which was served to the association.
No, you don't have any say in this. The authority's decision is final. This is a factual aspect you want to enter upon. Already how many buses are plying in the same route?
79.
79 buses are plying in the same route. Therefore, induction of 7 new buses in the same route.
7, Milord, not only 7 new buses, each of those 7 new buses have been granted 6 trips every day, up and down. 6 times they will ply. So 7 into 6, 42.
No, in your association bus timetable of your, each bus gets how many?
One trip per day, 1 up, 1 down.
They cannot decide how many trips.
No, they cannot. But the rational approach is already buses. Those buses are getting only 1 charge in a day, 1 up, 1 down.
Yes.
So association cannot apply, individual owner can apply that.
Now, Milord, I am covered by judgments, particularly in this context, specific dealing with this motor vehicle permits, which says that this discretion to be exercised by the RTO cannot be uncanalized, divorce any inquiry in this regard. Because the purpose is, any executive decision has a nexus with the objective it seeks to serve. The objective is, the conditions are laid down in the Act. In the Act, the Motor Vehicles Act says, availability of adequate vehicles considering the number of passengers. So before granting a permit, under the rules, there is no dispute with the proposition that the discretion of the RTO is final. I'm not saying that, but the discretion has to be exercised in a manner.
Aspect is what I'm considering. The already in the same route.
Yes.
The buses, maybe they are a member, may not be their member. They are getting chance for a trip for 1 day.
Yes.
How these new buses have been given chance for applying 6 times?
No, we have never stated that. Where from they are getting it?
Well, I have the timetable with me, page 44. And Millard, the timetable which has been granted to them is also there. I have annexed that. Millard, kindly sees page 44 is the timetable which we have last submitted to the RTO. And 31, page 31 onward, Millard would find each vehicle has been granted 3 trips up and 3 trips down.
So you are only interested about Alipurduar to Shankar?
Yes, yes, only with this route. This route. Now we have.
Mr. Bormon, can it be done?
Lordship, this chart has not never been prepared by us. So for the department, this is, we are.
No, you do one thing. You have to do that. You take control of that. Because you are the authority to prepare the chart. Right?
Till now.
Timetable you are authorized to prepare. They are only the association to look after that chart, that whether vehicles are flying with that chart or not.
Yes.
Take assessment of the entire vehicle of this permit of this route, including this 7-1, and distribute it according to whatever you. It may so happen he is getting 2 trips, other vehicle getting 2 trips, make it equalize. And for this purpose, the association can represent the entire bus.
Yes, yes. They can.
And
represent.
the new bus owners and the RTO sit jointly.
Yes.
To revise the timetable of the route between Alipurduar to
Rational.
Shankar.
Yes.
Right.
No difficulty. No difficulty.
Find out
Can
the
be asked, but the final decision is to be taken.
You
by-
take a decision,
course,
sir.
of
You take a
course.
decision.
The RTO shall prepare the timetable
Yes.
for all buses flying between Alipurduar to and from Alipurduar and Shankar. Is there any route number?
No.
Alipurduar to Shankar. All buses.
Yes.
All buses.
No.
And give this deliberation in the form of report before this court.
Yes.
And this report will sanctify that. That report will be sanctified. That you all buses should fly detailed report.
Yes.
This is the total number of buses in this route, including the 7 new one. Can it be done? Yes. This is the way it has to be solved. That what I require, the availability of the RTO Alipurduar.
Yeah.
It cannot be done by day after tomorrow. So you are required to sit with everyone. Then your timetable will also go.
No, I have no.
This is the RTO's timetable.
So far, my instruction is that
I
this
have.
association are fulfilling some bus owners and they are flying it as per the timetable fixed by the association.
No.
Which they are not permitted. Now this.
No.
Present added parties are flying.
These are Millard
No,
statements
the
from the bar.
petitioner is the bus owners association of the owners association of the buses flying in the route Alipurduar to Shankar. Stop. The association is aggrieved by the decision of the Regional Transport Authority Alipurduar to induct 7 new buses in the said route, and the timetable prepared by the said authority for the said 7 new buses. Stop. The petitioner's grievance, the petitioner's apprehension is that there are sufficient number of buses already in the same flying in the same route. The induction of 7 new buses with a timetable prepared by the RTO would cause a disharmony in the timetable. Stop. The transport authority under the West Bengal motor vehicle rules this is amended or this is
No,
latest one,
no, this is-
1989, is obliged to prepare the timetable for the buses, timetable for the stage carriage on a route or area, and its decision is final. Mr. Bormon, learned advocate for the state, submits that the association, petitioner association has prepared its own timetable for the buses plying in the Alipurduar to Shonghosh route, which is not permissible. Be that as it may, the uh, the respondent six, the regional transport officer, regional transport officer should by secretary, na? The secretary, regional transport authority, Alipurduar. The notice was issued by secretary.
Yes, secretary or TA Alipurduar.
Alipurduar is directed to convene a meeting with the petitioner association and with the owners of the 7 new buses, the added respondents hearing, to fix up the timetable for all buses plying in the aforementioned route. The said authority shall complete its drill in this regard within a period of 2 weeks from the date of communication of this order. Disposed of since no affidavit has been invited from the the allegations made in the petition are deemed to have been denied by the respondents.
Respondent by appearance.
Department, give your appearance on it. Take back your book.
Lordship 20, I'm praying for the next circuit, your Lordship. Kindly.
Yeah, Mr. Bormon.
Lordship.
Take back your instruction.
Kindly fix the matter.
Yes, next circuit, same order, huh?
Much obliged, Lordship.
On the prayer, stand over.
21, I am led by Mr. Pranjit Bhattacharya.
My lord, I appear for the writ petitioners.
You are not in Jalpaiguri.
No, my lord, I'm in Kolkata. My sister's wedding is there.
Oh, you will not be returning.
No, my lord. No. So, my lord, on 7th of December, my lord was pleased to grant me a liberty to file an exception to the report filed the Public Service Commission. My lord, I'm sorry I could not make it, my lord. So, and DM, as per that order, the District Magistrate Jalpaiguri has been added as a party respondent. Now, instructions from the District Magistrate is also awaited with regard to selection of the candidates.
You are appearing for the added respondent, district magistrate. Oh, you can represent the district magistrate. What is your instruction?
I think
Now his
my
role
lord.
is over. You are required to take steps for Ashun. Mr. Bhattacharya, learned counsel for the petitioner, pays extension of time to file the exception to the report of
The Public Service Commission.
the Public Service Commission. Prayer allowed. Let such exception be affirmed within a week from date. Stop. Mr. Bormon, learned counsel for the state, submits that He is yet to receive instruction from the added respondent. Added respondent.
6. Respondent number 6.
Added. Respondent number?
6.
6.
Yes.
And he,
6, my lord.
the district magistrate Jalpaiguri, the added respondent number 6. So, in view of the aforesaid, hearing the petition is that stand over.
Grateful, my lord.
Accepted.
Only two appear on the petition. This is the similar. Yesterday. Yeah. 2 matters are there, they have only one matter. Tomorrow.
The Jila Parishad, you are representing Jila Parishad.
Actually, we are not representing, but I think
No, already district magistrate, a portion of land, mineral 60 acres of petitioner was acquired by Jila Parishad. In the interest public. Very well, tomorrow. Last day.
Tomorrow.
Very well, Friday. So, in the Friday, there will be only 3, 4, 5 matters. So I have inspection. Huh?
I am from petitioner, Mr. led by Mr. Kunalji Bhattacharya.
My lord, I appear for the writ petitioners, my lord. I have served, but unfortunately, the affidavit of service, I have carried it along with me, my lord.
What is the matter about?
My lord, here the writ petitioners, my lord, are owners of a plot of land measuring about 54 kathas in Moja Dabgram, my lord. Now, if your lordship kindly comes straight to page 80. Now, this, my lord, I am inviting your lordship's kind attention to this. This is a power of attorney given by all the 3 landowners for the development of that land. Now, here, my lord, at page 88 are the schedules of the 3 lands. Now, my lord will kindly come to page 89, the 3rd schedule, which is the amalgamated schedule.
89.
89, my lord.
Yes.
Yes. Now, if your lordship comes to the 3rd schedule, the last schedule, my lord is there?
Yeah.
Yes. Now, my lord, I am placing it. All that piece and parcel of total amalgamated land at measuring 54 kathas, 13 chataks, more or less, situated within Moja Dabgram, jail number 2, sheet number 5, Toji number 3. Now, this is important, my lord. Recorded in RS Khotian number 219 by 1, 701, 745 by 1, 701 by 1, corresponding to LR 2214, 2215, and 1978. Now, what has happened, my lord? This power of attorney was executed on 15th of March 2022. Now, in and around, my lord, June 23, we again went to the concerned registrar's office to execute another power of attorney. Now, there we were told that because of an order of a trial court found by the appellate court below, the registration or dealing with the land in respect of these mojas, these Khotian has been stopped. Now, if your lordship kindly comes, we inquired about that and we were shown the letter at page 129. My lord is there? 129, my lord.
Yes.
Yes, my lord. Here, my lord, I will put in a caveat that we do not have any dispute with Ramakrishna Mission, my lord. Now, this was the first time this was given. This letter is dated 10th of July 2018. It says, my lord, the subject is addressed to the Inspector General of Registration and Commissioner of Revenue Stamp. Now, here, my lord, the body says, Sri such and such in deceit had gifted an immovable property comprising
Who are
an
you?
area.
Who are you? Who are you?
Yes, I am the landowner. The petitioners are the landowners of 54 kathas in respect of that Khutian, RS Khutian. Now, what has happened, my lord? The entire dispute in my respectful submission can be solved if the LR Khutian number of the suited property is, my lord, disclosed to us. If it is found out that the Khutians are different, my lord, then there is no embargo on me to deal with my property. If it is found that the Khutians are same, then it's a different story altogether. Because 2018, this letter was given to the registrar of registrars. 2022, my lord, I was allowed to register a power of attorney. Now, at page 133 is my representation, my lord.
I don't understand. The power of attorney you have executed to deal with your property.
Yes, my lord.
Now, the registering authority is not allowing you to transfer the property.
Yes, my
not
lord.
on the basis of the power of attorney.
No, basis of that letter, my lord.
No, why are you bringing the power of attorney story? No, state.
No, power of attorney, because, my lord.
It's an analogy. It's your analogy.
Yes, I'm grateful. My lord.
You have some property in a particular Khatiyan.
Yes.
Because of the pendency of a suit and appointment of receiver, the registering authority is refusing to register the sale deed.
No, subsequent power of attorney.
Huh?
I went to the execute another power of attorney.
We need to register a developer's power of attorney.
Yes.
So, in respect of the self-same property, if there is a receiver and other litigation.
Yes, there is a receiver. And my lord, there are pending suits between the parties. And
not with me, my lord. Not with me.
Ramakrishna Mission and these parties.
No. Subject to correction, my lord. Not with the writ petitioners.
But kindly have a look at page number 129. First
Yes,
is the title suit number 88 of 2010.
Yes.
Then there is misappeal pending before the
This is
learned
not with me, my lord.
They are the parties
not
to
with
that
me.
proceeding.
Yes, my lord.
I am not party, my lord. I am not party.
No.
On instructions, my lord, I am saying I am not party.
But this is the Ramakrishna Mission would be the best person to answer this. They have filed the suit.
No, which property you are dealing with?
And the property is the same, my lord.
Property, the
Lord, kindly have
identification
a
of
look
the
at page number
property.
130, the next page.
Yes.
After 129 and 130, kindly have a look at the schedule.
Yes, my lord, kindly see.
RS Khatiyan numbers 219 by 1, 701 by 11, 745 by 1, RS plot numbers, my lord, 110 by 192, 111 by 170, 111, jail number 2, Tochi number 3, Moja Dabra.
Yes.
Now, compare this, my lord, with the schedule.
Yes. But RS Khatiyan numbers might be different. I do not know the RS Khatiyan number of the suit property.
It's the same.
The LR Khatiyan, sorry, my lord, the LR Khatiyan. RS is
Khatiyan
known to me. That is what I have requested and the concerned authority.
Mr. Bhattacharya, do one thing.
My lord.
You have got the record of rights you have annexed over here?
Record of rights I have not, my lord. Because I have not.
Bring it tomorrow. Bring it. Copy of the at least one record of rights.
Tomorrow, very well, my lord. Day after tomorrow on the last date.
Yes. Can you not instruct your junior to bring that?
Yes. I can.
The record of rights, you are a recorded owner.
Yes, my lord.
So show your record of rights in respect of that. Okay.
Yes, my lord.
Bring it tomorrow. If you can tomorrow, then it is open. If it is not, then day after tomorrow.
Yes, tomorrow, my lord, I'll be candid. I won't be able, because tonight is the wedding, but tomorrow the morning the ceremonies are there. So
ceremony in the morning, wedding ceremony morning.
No, the wedding is today, my lord. It's the girls.
You are Bhattacharya.
Yes, I am from the bride's side, my lord. Tomorrow morning.
No, you are Bhattacharya. How can be the marriage ceremony in the afternoon?
No, my lord. Today evening.
Marriage is today.
Today is evening, my lord. Tomorrow afternoon she will be leaving for her
No,
matrimonial home.
in the daytime, in a marriage cannot be in your family.
No, marriage is post-marriage ceremony. And my lord, now I have become an elder
Post-marriage
brother.
hangover.
My lord, I close my
Very
case here, my
clearly.
lord. I
Very
close my
well.
case.
Last day, আচ্ছা নিজ day কটা হলো? দুটো হয়েছে।
Last day, my lord has kept 2 cases, my lord. No, Mr. Ghosh's case has been preponed to tomorrow.
Third one. আর কি আছে?
Grateful, my lords.
In the meantime, can Ramakrishna Mission should be served with an
Unnecessary.
Unnecessary, my lord.
They are the contesting parties in the
Yes, ultimately, if necessary, I will.
Yes, my lord. Because I don't have any dispute with Ramakrishna Mission. my
there's an order of injunction persisting prevailing at this point.
Yes. I'll also try to get the plaint, if possible, from the court, my lord. Grateful, my lord.
But I'm praying, my lord, 1 week's extension to prefer my reply to their opposition.
In civil division, opposition.
Opposition was,
What is the order about?
this was rejection of my prayer for injunction. Subsequently, my lord, injunction was granted, my lord, by Justice Bhattacharya, Justice Sobhasati Bhattacharya.
No. This is an against from misappeal.
Yes.
You are the petitioner.
Yes. Ex parte injunction refused by the lower court, appealed against by the district judge. Subsequently, under 227, we kept it. Both two rejections.
Appeal court
Rejected.
Appeal court also affirmed the
Rejected.
order of the trial judge.
Yes. We preferred this 227 application. At the first instance, injunction was
I'm
granted.
sure Justice Bhattacharya has not directed for affidavit in opposition. Now, what is that? The trial judge has taken it as a suit for injunction.
Trial judge treated it as a suit for declaration of title. I never sought for declaration of title. It was a suit simpliciter for injunction, permanent injunction. Because admittedly, the land was not recorded in my name. However, I had documents showing continuous possession since 1960s.
Suppose you are not challenging the erroneous record of
No. I cannot. My trade licenses, my electricity bills, I also used to run a brick field upon the land. All those documents
yes.
Was there. On the basis of that, Justice Bhattacharya modified the order granting me.
No. Why this injunction was there? At interim refused.
Yes, Millard kindly takes the order. This was treated to be as a suit for declaration of title. Millard, the first order of the learned lower court, with the first page of the order, the second last paragraph. On
No, ad
refusal
interim
of the
order
case
refused in appeal court. What the appeal court says?
Yes, Millard.
Order number 5.
Yes. But appeal court says, Millard, that I find the appellants file electricity bill, chokidari tax certificate issued by the GP and other connected documents in order to establish his title and possession over the suit property. In my considered view, no prima facie case has been made out by the appellant plaintiff, as well as there exists no such urgency which justify his prayer for an interim
Upon
injunction.
perusal of the case record and relevant document, this court, this is a trial court saying.
Trial court.
Corroboration of documents of title or possession.
Yes.
These are the primary documents which depict the claim as the plaintiff claimed by the plaintiffs. Depict the claim as often perusal prima facie. Prima facie. Found that document of title, not document of ownership. Thus, but possession can be arrived at, but the title
cannot be. I never claimed title. I cannot.
And what is the appeal court about?
My lord, the
Appeal code is.
my lord, appeal court, my lord, resonance the
Mr.
same.
Ramosai, since you have suffered the injunction for a long time, interim order, it is better you go back and contest this.
My lord, I proposed this on the last occasion.
Kindly
Mr. Mahasaya did
one
not
point.
agree.
This is a standard order.
Lordship,
Just 1
yes.
minute, 1 minute.
Only Lordship,
Take me to the plaintiff. And the appeal court is saying,
appeal code,
My lord, the plaint, my lord, is
letter
at
is page 60, 16.
16.
16, annexed A, A. And is a practically, this is a plaint is a for adverse position.
no, never tried to, by this electricity bill, he never tried to establish his position.
This position, but the
Now,
adverse position.
now, he is playing relief by way of adverse position.
Yes.
Where is the suit about?
Lord, the suit-
It is
suit
a
is
permanent
for
injunction.
Permanent
It
and
is a permanent
perpetual.
injunction.
Where? The plain,
My lord,
plain.
17, page 17. Page 17, 16, my lord, it starts. Kindly, my prayers are at page 29.
Have you initiated any proceeding for recovery of possession?
Lordship,
Have you initiated any proceeding for recovery of possession?
Lordship, recovery of position. If Mr. Ghosh is completed, then I may.
No, just tell me.
Lordship, first of all, I have filed one suit. Before, prior this suit, I have filed a suit for recovery of possession against this plaintiff. And that was the work-up property. The entire property is the work-up property, belongs to the worker. And as soon as I have narrated filed the plaint that this is the work-up property, learned advocate client repeatedly asked me that this is a work-up property, so he will go for a tribunal, and therefore 7 and 11, the order 7, rule 11 has been allowed, and that has been allowed. So 7 and order 7 and rule 11 has been allowed on the prayer of the learned advocate's client that the suit is not maintainable because of the work-up property is concerned, and that is been dealt by the work-up tribunal. And this is the bindings of the plaintiff, but that has been suppressed, and therefore he filed this.
No, not suppressed. In paragraph 17, he has stated.
Lordship, now, no, in the recent this appeal, the CO, the revision, he never disclosed that there is a suit is already been.
In the suit, he has disclosed.
Yes,
Paragraph
it was
17.
disclosed.
In a suit he disclosed, but in the appeal, that is, if he disclosed the plaintiff petitioner has been disclosed that the earlier occasion the suit one suit has been same property has been rejected by order 7 rule 11 on his part, and therefore a decree has been passed.
Have you ever anywhere you have stated that this property is work-up property?
No, never.
No. Millard, kindly says, in their earlier suit, which they preferred, the basis of the plaint was it is a work-of property. They claimed it to be a work-of property.
Very well. Then it goes.
Yes.
It goes. Now, in this case.
No, it's not a work-of property. I say it's a cash land which is under my occupation since 1960s.
Lordship,
I have never said it is a work-of property. I said,
Mr. Ramosha,
Lordship, I have filed when I filed the objection. My lord, kindly see the.
Wait, Mr. This is about an interim order.
Yes.
Lordship.
Now, question is, what is his cause of action?
Lordship, cause of action in respect of that permanent injunction, with respect of he stated that he is a adverse position. Tell me adverse position. Lordship, kindly.
No, that's the matter of
Lordship, kindly say para number 19, page number 19. Lordship, kindly see page number 19.
No,
Page
Mr.
number.
Bose, what is your cause of action?
Millard, my threat of dispossession.
Where?
Millard, it has been stated.
Where?
Millard, if Millard takes from para 13 onwards.
13.
Several FIRs were lodged, Millard, by me as well as them. Millard, they
Conspiracy.
So one thing, Mr. Ramosha, who are you? Who are you in the property?
I am the work-up property owner. I am the Mutawali.
You are the Mutawali.
Mutawali. I am the protector.
Very well. Unless you ventilate your case, the plaint has not. At the ad interim stage, only the plaint and injunction application is germane. What the injunction order is passed by my coordinate bench?
Coordinate bench is
not to disturb my possession.
Restrain me.
Not to disturb
my possession.
Wait, well, since he is enjoying this order of injunction.
That is been entirety, finality. Lordship, because of
No,
the
no,
permanent
no,
injunction.
no,
is-
no, just wait. Where is that order of injunction? It was passed on February 23, right?
Yes.
What is the form of injunction?
Form of
This one, the position of the with regard to the super till the disposal of the revisional application.
Lordship.
So no fruitful purpose would be served, keeping this revisional application pending.
Lordship.
I am remanding the matter back to the trial court, enabling you to file the written objection to the application within 2 weeks and directing the disposal of the injunction application within 6 months without being influenced by the fact that the High Court has granted order of injunction in favor of the
Lordship, kindly, I may be allowed one point, Lordship, because of the, prior to filing my version, this can be first dealt with the whether the plaintiff has been suggested earlier occasion that there is a work of
Mr.
property.
Raimoshai, I'll be keeping it open,
Lordship.
including, always you will attack the maintainability of the
Lordship,
suit.
that is me.
That is
I-
always
I-
open. Now, till the disposal of the revisional application, he is merrily enjoying this. That is why he wants to give the reply. It will be here.
Lordship, particularly trial court
See,
had, trial court had.
February, end of 23, useless by the time injunction could have been vacated or being made absolute. Asun.
Lordship, Lordship, kindly on the.
I'm fixing it. I'm not, this court, it should not be influenced by in any manner.
Yes, Lordship.
Asun. The revisional application is at the instance of the plaintiffs in a suit for injunction and is directed against the order order dated January 2023 passed by the learned additional district judge Jalpaiguri in miscellaneous appeal number 1 of 2023. Stop. The application of the plaintiff under order 39, rule 1 and 2, rules 1 and 2 of the Code of Civil Procedure. No, sorry, dispute of the plaintiffs in the suit. Sorry, the plaintiff's suit being title suit number 6 of 2023 is pending before the learned civil judge junior division at Alipurduar district, Alipurduar. In the said suit, the learned trial judge on an application under Order 39, which 1 and 2 of the Code of Civil Procedure filed by the plaintiffs refused to pass an administrative order of injunction by order dated
February. February. 2nd February.
20th January 29, order dated
Then
January
February.
9, 2023.
Lower court.
January.
Lower court. Stop. The plaintiffs aggrieved thereby have preferred the corrected miscellaneous appeal. The appeal court below by the order in view has affirmed has dismissed the said appeal and has thereby affirmed the order of the legislature. The revisional application was admitted on February 10, 2023. And an ad interim order of injunction restraining the defendants opposite parties from disturbing the peaceful possession of the people over the suit property was passed till the disposal of the revisional application. Stop. No fruitful purpose would be served in keeping the revisional application. Instead, in my opinion, justice would be subserved if the pending application for injunction is disposed of on contest. Therefore, the learned trial judge is requested to deposit the said application within a period of 6 months from the date of.
1 month, 2 months, because of
ঠিক আছে, 4 months from the date of communication of this order. Stop. The defendants are permitted to file written objection to the said application within a period of 2 weeks from date. Stop.
No,
Rejoinder, if any, be filed by the plaintiffs within a week from the date of receipt of copy of such written objection. Yes, stop. It is made clear that learned judge, trial judge, while deciding the application for injunction shall not be influenced by the fact that this court has passed an order of injunction in favor of the plaintiff's petitioners. Stop. Disposed of without any order.
Similar candidate records one line that this order shall continue till disposal of the action.
Oh, sorry, I said that last time. The order passed by the High Court in this matter shall continue till the disposal of the injunction.
Yes, great.
My lord, learned senior for the petitioner is engaged in his mother's treatment. She incurred heart attack last night. Yes, my lord. So we could not come today.
When handwriting experts can be appointed.
My lord, next circuit.
Next circuit, handwriting expert can be appointed.
Oh, my lord, I am not instructed about that.
Next circuit.
But I am for the opposite party.
My lord, in this matter, I am praying for not today, lord. Actually, my lord, my learned senior is out of session for some person.
Suggestion made during cross-examination was disallowed against that they preferred this. Order dated 22nd February 2023.
What kind of cross-examination?
One of kindly sees the third last paragraph. Further cross-examination of DW1 resumes today. Learned advocate for the plaintiff cross-examines DW1 in part. While cross-examination, the learned advocate for the plaintiff puts a question to DW1, suggesting whether he made certain statement in his written examination in chief. The court refuses to entertain such question as it is a matter of record and certainly not relevant in view of section 5.
Lordship, kindly it may
What is
fix
the
tomorrow.
evidence in chief?
Lordship, I am not instructed about that.
What is evidence, chief?
If it-
What is affidavit in chief?
if it-
Which college? Which college?
Oh, Eskachari Institute of Law.
Huh?
Eskachari Institute of Law.
This is here.
No, Kalyani University.
Kollam University. What is evidence in chief?
Lordship.
Have you ever seen order 18?
Lordship, I am not.
You do not do civil cases.
Lordship, we do actually, but I am junior actually.
Junior, you pass the law. You have not heard about order 18.
No, I have heard actually.
Now, after 2002, instead of this witness box, everyone, the plaintiff gives or the defendant gives his version, evidence in writing under order 18. Right?
Yes, Lordship.
Now, a question whether you have made this statement in your evidence in chief, what is the relevance? Already he has stated, instead of standing there, he has written. And court has rightly disallowed it. And your senior rightly is desired. What can be done, Mr. Pal?
Not today.
Not today. Tomorrow, ask him
Yes,
to be
Lordship.
present.
Let these matters appear in the top, my lord.
Lordship, tomorrow my senior will present.
I don't know what.
With
they
other
do
civil matters,
now,
my lord, in the top.
unless the
Why?
civil matters moves. How many districts are coming? So many civil matters. Do not allow the civil matters.